Okay, perfect. Hi, everyone, and welcome to the Marketplace Risk Virtual Event Series. My name is Andrea, and I'm the Director of Events and Logistics here at Marketplace Risk. Today, we welcome Jennifer Morris, Senior Counsel at Cypher. Our virtual events are designed to help marketplace and sharing economy startups successfully navigate complex risk management, trust and safety, compliance, and legal subject matter so they can avoid distractions in order to focus on launching and growing. Be sure to check out marketplacerisk.com to access hundreds of hours of content, including our master's program, platform, podcasts, and previous live events. And to subscribe to our newsletter where we keep you up to date on everything, including the Marketplace Risk Management Conference in San Francisco and the Sharing Economy Global Summit in London. If you're interested in sponsoring or speaking at one of the events, or you want to submit your ideas, please do so at marketplacerisk.com. The call for speakers for the conference has closed, but if you're interested in sponsoring, email us at info@marketplacerisk.com. In the Sharing Economy Global Summit, speaker deadline is August 15th. Thank you everyone for tuning into today's session, Marijuana in Marketplaces, Best Practices for Clearing Through the Haze. First, a couple housekeeping items. This webinar is being recorded, so the recording will be available for you to access on the Marketplace Risk website. Second, all attendees have listening capabilities only and are otherwise muted. And third, do submit your questions via the control panel. If we have time at the end, we'll answer as many as we can. If we don't get to your questions, feel free to email us at info@marketplacerisk.com and we'll get your questions answered. And now, without further ado, Jennifer, over to you.
Thanks so much. Good morning or good afternoon, depending on where you may be joining us today. I'm really excited to be here. My name is Jen. I'm a senior counsel with Cypher Shaw at San Francisco office, and I've been working with employers and some marketplace companies with respect to their drug and alcohol testing practices, which, as you probably know, has become a hot topic given marijuana legislation and how it's really spreading throughout the country. Before we get started, I just want to do a quick legal disclaimer. As you probably or you all know, and you've attended tons of these, you always hear this, that everything I say today is for informational purposes only. Nothing should be construed as legal advice. I do encourage you to ask questions in the chat, and we will have some time at the end to answer questions. If we don't get to them, you certainly can reach out to me directly, and I'm happy to help you. But if you're going to ask a question in the chat, try to keep it general and not something very specific for those you might want to confer with your counsel that helps you with these types of issues. So what are we going to talk about today? One thing I want to caveat is that I know that many of you or most of you try to treat your workers as, outside of the employment context. Most of what we're going to talk about, actually all we're going to talk about today, are the recreational and medical marijuana laws and some drug testing laws that do specifically to apply to employers and employment relationships. We aren't really sure right now what's going to happen over the next couple of years, whether or not courts or plaintiffs' attorneys or what have you are going to take the position that they apply to contracted work or other non-employment type relationships. But I'm sure that you all, those joining you today, do have employees. Maybe you're drug testing your employees. I also do know that there are some companies out there that do follow some of these laws when it comes to allowing people to use their platform to sign up for services. So it could be a driving type job. And maybe there are contractor or third party relationships that you have that might mandate some of these. So this will give you an idea of what those third parties might be facing, in terms of their own requirements under the law. Maybe you're having some questions or issues with respect to your own employees, or this will at least give you kind of some ideas or things to think about as we progress over the next couple of years, in the event that we start seeing that more and more of these laws do apply to contracted work or your, not traditional employment relationships. So we're going to talk briefly about the current state of the law. We're going to talk about what happened in 2021. As you'll hear, it was somewhat of a busy year. It has been busy the last couple of years, but what you'll see is that we had a couple of states pass some pretty aggressive marijuana laws that are, at least for employers, really giving them heartburn, and they're really trying to figure out how to navigate that. So that's why there was a big focus on 2021. And then one question that a lot of companies are starting to ask is, should we be even testing at all? And if so, when or who, or what types of positions, what should we be testing for, things like that. So what I'll do is I'll walk through sort of the considerations that companies might want to think about or discuss with their stakeholders, because there have been some news reports about companies that are eliminating marijuana testing, or maybe they're doing so for in the pre-employment context. And so I've been getting a lot of questions lately from companies, well, should we do that too? And it's not really, there isn't a yes or no bright line answer unless you're a regulated employer and you absolutely have to test. So I'm going to try to go through some issues that companies can start thinking about, if they want to, if they're considering this very important question. I'll go through a few other considerations, some closing thoughts, and then we'll leave some time for Q&A. So what's going on right now? A lot of people view the marijuana issue as fairly political. That's probably still somewhat true. I'm not necessarily sure it is, especially since we know that about 2/3 of Americans, the last Gallup poll shows that 2/3 of Americans support legalization of marijuana, even at the federal level. And that's a pretty large number. It's been growing over the last couple of years. You can see from this slide that, we have two former presidents who have very, very conflicting views about marijuana. And then we have a former Republican governor who, presumably, and I'm sure this is still his position, was pro-marijuana or not necessarily against it, especially in the way Reagan was. So this just at least highlights that it's really not necessarily a political issue that we might think. Hopefully you don't see my toolbar at the bottom. So right now, cannabis still is illegal under federal law. This has been the case since the early 70s when it was added to the Controlled Substance Act as a Schedule I substance. What does that mean? That means that it has the highest potential for abuse and it has low medicinal value. That's how something ends up as a Schedule I drug. So you've got heroin, you've got PCP, things like that. Interestingly, cocaine is a Schedule II drug because it can be used for some medicinal purposes. But right now, under federal law, it's still a Schedule I drug. Every year, with every administration, somebody talks about, let's do something about that. The federal government seems to have taken a very hands-off approach with respect to marijuana. I think with the current war in Ukraine and COVID and the economy and inflation and all the various other things going on right now, whether or not this is a priority for the Biden administration remains to be seen. So, we'll just kind of track that at the federal level. But really where we're seeing the activity is at the state level. We're seeing that states and now even localities are starting to get into the business of regulating this. They're passing laws purporting to legalize cannabis. And so that could be a medical marijuana law, which I'll show you some slides. Most states now have one of those. Recreational, I think that's doubled in the number of states in the last couple of years. And then decriminalization. The difference between a recreational marijuana law and a decriminalization law is that decriminalization just essentially says that, yes, marijuana is illegal, but law enforcement is going to take a hands-off approach, or prosecutors aren't going to be prosecuting people for it. So you might have decriminalization in a state that doesn't necessarily have a recreational law. If you have a recreational law, like in California, New York, New Jersey, et cetera, then it's purportedly fully legal at the state level. And I always say purportedly because who knows what the federal government or the U.S. Supreme Court is going to do. Many of these laws have express or implied protections for workers. They don't, New York didn't call California and say, hey, what did you do? Or, these states don't talk to each other. They're not trying to at least model their laws after each other so that a nationwide company can have a one-size-fits-all approach with respect to how it treats marijuana use in its workplace. What we're actually seeing is that in the early years, the states were very pro-company. California, Oregon, Washington, Colorado, surprisingly, all the West Coast states are still very, very pro-company. Employers can still enforce their drug testing policy, their drug-free workplace policies, things like that. And now we're seeing this shift, and we'll talk about this shortly, where states are starting to really crack down on companies and how they consider cannabis use among their workers. And they seem to be getting more and more pro-cannabis friendly or cannabis friendly as we see these new states crop up. Litigation is growing. If any of you subscribe to Law 360 or Lexology or any of the employment related blogs, you'll see that I think at least I don't know if I'd say weekly, but it's starting to seem like weekly I see a new lawsuit filed against somebody. I think recently I saw one filed against a hospital, and really all the claims focus on medical marijuana use. Plaintiff will sue saying you didn't accommodate me or you didn't engage in an interactive dialogue. And the litigation is really gaining traction. Early on, the court decisions found in favor of companies, again, all on the West Coast, no duty to accommodate. There's been this huge trend, though, on the East Coast, Massachusetts, Delaware, I believe Connecticut, all having court decisions that found on the side of the applicant or the employee, really because the employer essentially just completely rejected the person for the job without any consideration for whether or not the medical marijuana use would cause any safety risks or undue hardship or things like that. So employers are really starting to, or companies just generally are really starting to pay attention to this because they don't want to be sued. And, you know, with these cases kind of all saying different things, they're all analyzing different statutes or analyzing different issues. It's such an evolving area of the law, and even I'm trying my hardest, along with all of you and other employers out there, to kind of keep up. Medical and scientific opinion has changed. Again, you know, while being a Schedule I drug means there's apparently no medicinal value, we're starting to now see over the years people taking the position that cannabis actually can treat some ailments. Whether or not that's true, I have no opinion of. But apparently medical and scientific opinion is supporting that conclusion. As mentioned, we're having a cultural shift. Gallup poll says about 2/3 of Americans want to legalize, or at least see it legalized at the federal level. And it's just becoming difficult, as I mentioned, to navigate all of these laws depending on where the company is. So jurisdictions that currently authorize medical use are all on this slide. Those that are, and you can see this is more than half, those that are in bold and underlined are what we consider to be those that provide some sort of a protection to a job applicant or somebody requests, you know, again, I don't know if these apply to people who are seeking an engagement or some sort of contracted work. I think that's going to really kind of depend on the state and the jurisdiction and how they're reading these laws and interpreting the separate employment and independent contractor laws. So when I say the states have worker protections, that means in the employment context right now, but some of them are based on statute and some are case law. So what that means is that some specifically say in a statute, for instance, Arizona, that a company cannot take action based solely on a positive test result. That's a pretty positive THC test result. That's a pretty pro-applicant, pro-worker provision, because it essentially says that the only time in Arizona a company can take action against somebody who's tested positive for marijuana is if there's reasonable suspicion or some sort of evidence of impairment at work. There are a couple of other states that have that requirement. From case law means that the law isn't really clear on what protections it provides, if any, but because of some of the language in the statute, or really what we're seeing is that plaintiffs are suing based on a disability discrimination theory. We're starting to see courts interpreting the medical marijuana statute as providing these types of employment protections that some other jurisdictions have specifically put within their statute. So that's kind of the distinction there. Recreational, as I said, I think doubled in the last several years, most recently Connecticut, New Jersey, New York, Virginia, and New Mexico, all passed recreational laws just in 2021 alone. South Dakota has a double asterisk because the state Supreme Court held that the recreational marijuana law there is unconstitutional. What that means for the future of that law remains to be seen, but I at least wanted to include that there as kind of a state to watch. So let's talk briefly about what happened in 2021. So New Jersey, earlier in the year, passed the CREAM Act. It's created quite an uproar among companies because, it does have some protections, but what I will say with respect to at least the first bullet on what companies can do, prohibit marijuana use or possession or impairment in the workplace, I mean, that might sound like they're throwing employers a bone or companies a bone, but at the end of the day, no state requires a company to allow somebody to use cannabis while working, possessing while working, or while on the job, or being impaired at work. But New Jersey felt it important to be able to specifically say that, which is great. In New Jersey, companies can still require people to submit to drug tests. We'll talk on the next slide about whether that's actually true or what that actually means in practice, given some of the other wonky drug testing provisions that the state put in its marijuana law. What companies cannot do is refuse to hire or employ someone who uses marijuana unless there is some sort of federal prohibition or an issue with respect to federal funding, and then take action against someone based solely on a positive test result for marijuana. And so what that essentially means is that pre-employment drug testing or THC testing in New Jersey, I don't want to necessarily say it's illegal, but if you can't use it, and that's what the law says, you can't take action against somebody who's using, and somebody who's tested positive before they start working for anybody is not using at work, it's off-duty use, then it would be illegal for the company to not hire that person. And same with the second bullet. The scary thing about New Jersey, and this is the same for New York, and this is what got everybody upset and up in arms in New Jersey, is there's no exemptions at all for safety-sensitive workers. And so our firm has been dealing with a lot of companies in that state that have, very, very highly, very risky places to work, manufacturing, lots of things going on that could create explosions, things like that. And so they're asking, well, what are we supposed to do here? And, the answer is really up to the company and what sort of risk it wants to take. But right now, New Jersey doesn't have an exception for safety sensitive workers. They are working on some regulations to deal with a separate issue that I'm going to talk about, and whether or not they address that remains to be seen. The case law in New Jersey that has addressed medical marijuana use, so a plaintiff has sued because they applied for a job or they worked for a company and they tested positive and either lost the job or were fired. They did not involve safety sensitive roles. And so nobody, at least in that state as of yet, there hasn't been a court decision that has gone through, well, whether or not this particular rule or requirement should apply in this context, given the nature of the work. So in terms of New Jersey drug testing, employers can absolutely, or companies can absolutely still conduct drug tests. But as I mentioned, it effectively bans pre-employment drug testing, and a positive drug test result for THC is really only going to be defensible if it's based on reasonable suspicion. Because, again, if you think about somebody who is used and they've tested positive, it could have been 2 weeks ago, they might not have been at work, they might not be impaired anymore. And so if you don't have indicia of impairment, if you don't have any indication the person is actually high or loaded at work, then you're going to have a really hard time defending any action you take against that person, because their argument is going to be, you have no evidence I was doing anything at work. And the law says you otherwise can't take action against me for something that I'm essentially doing in my own time. The other problem is that even if you're going to do a reasonable suspicion drug test in New Jersey, the state statute has some requirements in terms of what your testing program must look like in order to do that. So first, you have to use a reliable, scientifically reliable objecting testing method. So that's blood, urine, saliva. In my experience, most companies use urine anyway, so they're going to be fine there. What they do also require that is new and not found in any other jurisdiction is a physical examination by a workplace impairment recognition expert. What is that? That is a person that a company has to hire. It could be full-time, it could be part-time, who is going to be trained to detect and identify if somebody is using any sort of drug or intoxicating substance at work. So they essentially have to do a physical exam, and the person has to go through some training. Now, the commission is currently working on creating training and certification requirements in consultation with the state police. They were supposed to release those rules and requirements last year. What they did instead is they released a bunch of personal use rules, and they had one small paragraph that said, we still don't have our rules or regulations on the wire, And so until then, employers or companies don't have to do this physical exam. So this doesn't actually have to be done right now. So I suppose that's good news, but we'll be monitoring the New Jersey Commission to see when those rules come out and what this all looks like. Again, are they going to address safety sensitive jobs? So you've got people driving for you, you've got people going to people's homes, whatever it might be that you might deem as a safety sensitive role, or any company does. It would be nice if New Jersey would address that issue. I know that business groups were pounding pretty hard on the state on that issue. Whether the state listened, we don't know. New York, then Governor Cuomo signed a recreational marijuana law in March of 2021. What that state did is it amended its off-duty products law. So what is that? An off-duty products law is a statute, I think there's maybe a dozen of them across the country, that says employers or companies can't take action against people for things they do outside of work that are illegal. It's my understanding, I haven't gotten into like the history behind this, but it's my understanding that these laws were passed to protect people who smoked or drank alcohol. So if somebody smokes, they're not doing it at work, and it's otherwise not affecting the employer, or same with alcohol, employers couldn't be rejecting them for jobs or terminating them because they're doing something that's legal. So what New York did is it had an existing off-duty products law, and it's actually an anti-discrimination provision that essentially says it's discrimination for an employer to take action against people who are doing certain things that are legal. And what New York did was it amended that law to specifically refer to cannabis. So essentially now, unless a company has evidence that somebody is impaired at work, then any drug test or action taken against somebody because they've tested positive, or they smoke pot, maybe cannabis outside of work, that would not be defensible, because presumably it's off-duty use, it's legal under state law, and therefore it can't be considered. And even the Department of Labor put out an FAQ a couple of months, I think 2 months ago, specifically saying companies cannot test people in a pre-employment context, period. End of discussion. And of course, again, no exceptions for safety-sensitive jobs. The law says that employers or companies can still maintain a drug and alcohol-free workplace. Like I said, that's the same everywhere, and they're not required to accommodate the use, possession, sale, or transfer of marijuana in the workplace. Again, no state requires that an employer do that or a company do that. So New York, again, causing a lot of heartburn for companies over there, because especially those that have workers who are working in safety-sensitive roles. Whether, again, I feel like I have to keep saying this, whether this is going to ultimately apply to contracted work or other types of non-employment type relationships remains to be seen. It's my understanding that the New York Department of Labor is extremely aggressive on these issues, and so it wouldn't shock me if we start seeing some sort of position that they take with respect to marketplace type entities. So that's just something to watch for out there. Connecticut, their statute was ridiculously long, but it was, when you really got down to it, the law specifically says that so long as a company has a drug-free workplace policy that is compliant with the state drug testing statute, then the company can pretty much do whatever it wants. That policy has to be distributed to people in advance. And when I say a drug testing statute, there are about a dozen, maybe 15 states that have specific drug testing statutes on the books. They're separate and apart from a medical or recreational marijuana law. And those statutes talk about what companies have to do if they want to actually drug test their workers. So some of them will say you have to have a policy and it has to say X, Y, and Z. Some of them will say you can't do random unless A, B, and C. Some of them will say, you can only test for certain types of specimens. So that's just something to keep in mind, that when we're talking about medical and recreational marijuana laws, those are always going to be different from the actual drug testing statute. So this is an example of a jurisdiction where the recreational law specifically refers to its own drug testing statute and says, look, if you company have a policy that complies with Connecticut law, great, you can essentially do whatever you want. Just make sure that your applicants and your workers have seen the policy in advance that way that they can know what the expectations are. There are some, well, actually, there's so many exceptions in this law that you have to ask yourself, who does it even really apply to? Quite frankly, it was very, very painful to read. Virginia and New Mexico both also passed recreational marijuana laws. Neither of them say anything about protections for workers. New Mexico's medical marijuana law, though, is considered one of those worker-friendly jurisdictions. So that's just something to keep in mind there. And then Virginia passed its first statute protecting cannabis oil users. So we'll start seeing what happens with respect to cannabis. And we're going to talk in a bit. We have a slide that talks about kind of the issues with respect to CBD oil, which is just a huge, insanely huge industry right now. And it's creating a lot of problems for workers and companies alike. So that's just something to watch there. I believe that in order for the cannabis to be protected, it's a very scientific definition of CBD oil in the statute. It has to have a certain level of CBD in it. Because based on a lot of the science out there, CBD really only works if it has certain levels of CBD within it. And the FDA, we'll talk a little bit about how the FDA doesn't regulate it right now. And so there's lots of shenanigans going on about what's in CBD oil products and things like that. Philadelphia, as of this year, it followed the lead of New York City, which banned companies from testing applicants pre-employment for THC. The New York City law, in my view, is pretty much gone or doesn't even matter anymore since New York State has taken the position that companies shouldn't be testing for THC before they start working, period, at all. Philadelphia basically copied the New York City law almost verbatim. And it essentially just says that companies can't be testing for THC before the person starts working. There are a bunch of exceptions. The city is supposed to issue rules to clarify what it means for a job to be safety sensitive. Since Philadelphia essentially copied the New York City law, it wouldn't shock me if Philadelphia just copies the New York City's rules on the definition of safety sensitive, but we'll be monitoring that and reporting on that as well. Okay, so, this is kind of the big question that a lot of companies have been asking is, should we be testing? And if so, who should we be testing and why and when, and what do we do with the information? So, one important thing to consider is, what does a positive test result even tell you? It doesn't, right now, science has not caught up. I always joke that whoever comes up with a test that can show somebody is actually impaired at work is going to be a very, very, very wealthy person. Because this is a test that actually, is really, really needed right now. I think even law enforcement has been struggling with this because when they pull somebody over on the road, they don't have a test available to them like the breathalyzer that will tell them, yes, this person is actually impaired by THC right now. And so when you test somebody pre-employment, right, what does that even say? That just says, okay, well, prior to applying for this job, they smoked cannabis or ingested cannabis or inhaled it or whatever. And then even if you test somebody that currently is, working for you or on your platform, again, what does that tell you? If there's no indicia of an impairment, maybe they had an accident and you set them out for a test because they're in a driving role and it's safety sensitive and it comes back positive. If there's no other indicia of impairment, they otherwise seem fine. What does that test tell you? Again, it just says that they could have used it in the past. It's hard, it's difficult, or almost impossible right now to make any assumptions about it. It lingers in the system. I mean, depending on if somebody is a chronic user, it could be, it could have been from, they tested a month old or they used a month ago. I mean, that's how long it stays in the system. If somebody is a casual user, then it might have been out of their system by then, but we just don't really know. And then, one of the other considerations is, can you even test? Again, if you're like some of the marketplace entities that are following some of these laws just to be conservative, one question to ask is, well, are we going to expose ourselves to a claim in some of these jurisdictions if we continue to test, especially in the pre-employment context? And it's important, if you're going to consider testing, to develop and administer a strong reasonable suspicion policy, because Again, if you're worried about litigation in any of these high-risk states, especially those that say we can't test, or we can't rely solely on a positive test result, then it's really going to be important to have a strong reasonable suspicion program. So what does that mean? So reasonable suspicion is basically a reasonable belief that somebody is impaired or under the influence of work based on objective manifestations or clear observations of their behavior, their appearance, their speech that might be associated with drug or alcohol use. And look, this isn't just limited to THC. This is for alcohol use. This, somebody might be using methamphetamines. I mean, all of the training that a company would give to those tasked with making reasonable suspicion determinations should understand what the effects of all of the drugs that you're testing for look like, and the effects of alcohol as well. One question that gets asked a lot is, well, what if we hear this information third hand? Or we just employee calls and says, so-and-so is a methamphetamine user. What do you do with that? I think that's hard. I've actually been dealing with some situations lately, two situations lately, where a customer will call and say they had heard rumors that the person was a drug dealer. And then the question is, well, should we test this person? And you got to be really careful with hearsay evidence. I mean, you certainly can talk to the person and say, hey, so-and-so called and said that, you've done X, Y, and Z, what say you? And make a determination from there. But I think it'd be a little risky to just send somebody from a test just because some random person off the street called and reported the person. What if you catch them using or possessing at work? In my view, again, this is obviously up to the company. In my view, you take action based on that. Again, no jurisdiction requires a company to allow its workers to bring it to work, to use it at work, anything like that. So if your policy is clear on that, I see that as a policy violation. I'm not really sure the need to send the person for the test if you have clear evidence that they were caught using or possessing at work. What's the point? You're going to take action against them based on the fact that they violated what I assume are clear policies. And so the test isn't really going to help you anyway. It's really important with a good reasonable suspicion program to document. The documentation and the test itself should be as soon as possible, quite frankly. I've had situations where companies have called me and they want to test somebody 3 days later based on, well, they were acting weird and they smelled, and it's like, well, why didn't you send them that day? It doesn't make sense that we waited 3 days and now, it's kind of, we've lost the opportunity. So it's always better to send them as soon as possible. It's always better to document. I've helped clients work with reasonable suspicion checklists. So at the top, you put the person's name and who filled it out, what their role is, what time, what date, what they saw. And there's a bunch of boxes they can check off, appearance, glassy eyes, they smelled like fill in the blank. And then so you could, maybe there's some issues with work performance, I think. Yeah, work performance. So maybe the person has been late a lot. Maybe they're leaving work early, especially on Mondays or Fridays. Any sort of physical signs, though, and behavior characteristics, those are going to be the ones that are most often seen and on the checklist. So glazed eyes, their slurred speech, they're drowsy, maybe they're sweating a lot. Maybe they're overly defensive, they change friends at work, they're having unusual temper outbursts. I've been working with a very large company right now on its remote reasonable suspicion policy. So that's how to detect somebody is under the influence or impaired through a Zoom meeting. And so that's really going to depend on, having very open ears and very open eyes to detect, what is going on. Because that's a lot harder to deal with, but it's entirely possible. So, it's important that people understand what the signs are, and so they can make a very objective decision about whether to send somebody for a test. So the big consideration for any organization that's thinking about whether it should stop testing is safety. So the National Institute of Drug Abuse has indicated that there are 14 million active drug addicts employed or working at any given time. It's a lot of people. And so companies have an interest in making sure that they offer a safe work environment. And in fact, they're required to do so under OSHA's general duty clause. which says we will maintain a safe work environment. OSHA hasn't really, I don't think at all, spoken about the cannabis issue, and I'm not sure what they're going to say. We know that problems caused by marijuana include accidents, injuries, performance issues, and these really definitely result in increased liability to the company. I mean, one thing we get asked a lot is, well, what happens if we stop testing people, or we do test people, but then we pass them for THC and then they go and cause a crash? Are we going to get sued for that? It's like, well, it's possible somebody's going to bring a negligence claim, right? So somebody tested positive, you hired them, they then contributed to an accident, and when they tested positive, then they were also using marijuana. I mean, it's entirely possible, and that's why companies are so sensitive to this issue. And there are many out there who take the position that, look, anybody who's in a safety sensitive role is going to be tested, and they try to navigate the laws to the best that they can, but they recognize that they don't want the reputational risk, they don't want the lawsuits, and they certainly don't want people getting killed or injured while at work because somebody was high and came to work and got on the road and killed somebody. The National Safety Council for Safety Sensitive Jobs recommends zero tolerance. What is a safety sensitive job? So, I always kind of ask, is it a job that if a person is high under any, high based on any drug or drunk on the job, could the impairment cause death, injury, property damage, things like that? So driving seems obvious. Conveyors, forklifts. I would take the position that medical people who are working in medical jobs are safety sensitive. One thing to note, if you're dealing with third parties or customers that are subject to this, there are certain federal statutes that require drug testing. So Department of Transportation, anybody who's operating a commercial motor vehicle, or anybody who's flying a plane, things like that are all subject to mandatory testing. And the DOT has come out and said, we don't give a hoot about what any of these states say. People who test positive for THC cannot perform safety sensitive work. But I would say safety is the biggest consideration that comes to companies' minds when they're considering whether or not to continue testing. And oftentimes that means that maybe the company will continue to test for safety sensitive, but not test at all for your desk jobs or people who are not in safety sensitive jobs, or maybe even discontinue all pre-employment, but continue to just test during employment. So there's lots of options, and we'll talk about those shortly. Another consideration is the culture, right? So again, 68% of Americans support legalization. This was 2021 poll. Job market considerations, that's actually been somewhat of a huge issue for some companies. And I think that if you've heard about some of the very, very large companies that have stopped testing for marijuana pre-employment, it's because they're finding it hard to hire people. They're having a hard time because we have so many states that have legalized marijuana, whether it be medically or recreationally, and people aren't passing drug tests. Or an applicant might learn that passing a drug test is a condition of employment, and they just self-select out of the process or don't apply at all. And so in order to ensure that we can continue to hire people and keep business moving, some companies have made the decision that, look, we have to get bodies in the door. We need workers. And so we're willing to at least eliminate it pre-employment so that we could increase our talent. Now, this might not apply to many of you if you don't have employees. Again, it's going to depend on how a state views its disability discrimination law and whether it covers contracted work. There's no duty, but the accommodation issue is a big question, and the reason is because it can kind of be somewhat of a headache. So right now, under the Federal Americans with Disabilities Act, there is no duty to consider accommodating somebody with marijuana because it's still legal at a federal level. The problem is that there is still a duty under federal law to accommodate the disability. So, for example, applicant says, I have epilepsy, I need to use my medical marijuana card. According to the ADA, you can't just say, too bad in discussion, go away. You still have to at least say, look, we're not willing to accommodate the medical marijuana, but we understand you have epilepsy, and here are your limitations, and what is it we can possibly talk about besides using marijuana that would help you perform the essential functions of the job. States are going the opposite way, though. We're seeing Massachusetts, Connecticut, New Jersey all have state Supreme Court decisions that have found in favor of applicants. In all three cases, either an applicant or a worker came forward or they tested positive and they said, hey, I use medical marijuana. And the company just said, too bad, you're out, and didn't engage in an interactive dialogue at all to see whether or not they could accommodate the marijuana, or if they couldn't, are there other reasonable options available? The Massachusetts case was wild because it actually said that the employer has to consider other possible medications that might allow the person to do their job aside from marijuana. Now, employers, companies, they're not doctors. How do they know what other medications might be available? It seems to me that that's something that the applicant or employee's doctor should be fleshing out in the accommodation certification form. But that was actually one thing that the Massachusetts court said companies had to do. But in accommodation, I mean, a lot of companies are now starting to at least go through the process because they don't want to, risk a disability discrimination lawsuit. Just because somebody makes the request does not necessarily mean you have to get it, but a company can at least avoid a failure to engage in the interactive process claim if they have the conversation and go through it, and maybe they've decided that allowing the accommodation would be an undue risk, and so they're not undue burden, so they're not willing to do it. Maybe they're willing to do it. I've worked with a lot of companies that have said, fine, that's, and they just remind them, don't use it at work, don't come to work high, don't bring it to work, things like that. So usually the requested accommodation, or I think always, is like bend your drug and alcohol testing policy, or your substance-free or drug-free workplace policy. So your policy would typically say people have to pass a drug test in order to start working. So somebody tests positive, what they're essentially saying is, you should accommodate me by letting me slide past the drug testing policy or that particular rule. And then it would be the same for the general prohibition against, using drugs. I've seen some drug testing policies or substance abuse policies that talk about, essentially not using drugs at all. And so if an employee or an applicant has said, I used it medicinally, then you're going to have to bend that aspect of your policy such that they're not in violation of it. So that's usually what the accommodation is going to look like. So what are most companies doing? So what most companies are doing is business as usual. They're just continuing to test. Maybe they've come up with kind of a matrix of, if somebody's in these states, then we do, and they don't. If somebody is in these states, maybe there's like 50 states out there, or I'm sorry, 40 states out there that you're going to continue to test for everybody. You're going to continue to reject people, and you're going to continue to do reasonable suspicion. But if somebody comes forward and says it's medicinal, then they'll deal with it at that time. Some will have state by state. So they'll look at the state where the person is and they'll just follow the law there. There are some that have just said, we're going to stop doing pre-employment altogether for everybody. I haven't seen that. I think I've only heard about that in news reports, but I haven't actually seen that with any of our clients. What I have seen with some of our clients is, and again, anecdotally, is eliminating pre-employment for non-safety sensitive, but continuing to do pre-employment for safety sensitive. I think in my experience, everybody's still doing it for safety sensitive, for pre-employment and during. You're always going to want to continue to do reasonable suspicion, at least for your safety sensitive people. Whether you do that for non-safety sensitive is again up to the company. There was a Walmart case where somebody did in Arizona where I think somebody working in a desk job injured themselves, or they had carpal tunnel. It was a wrist injury, and for whatever reason, Walmart sent them out for a drug test. The person failed. They fired her. She sued and won on summary judgment because there was no evidence that she was high at work. Walmart's HR manager testified that, well, based on these numbers in her drug test report, she must have been high at work. And the court said, you're not a scientist. How do you know that? Which then begs the question, does this mean employers have to start presenting expert testimony if they end up in litigation over a drug test? Don't know. That seems to be what's going to have to happen in Arizona. But this highlights why it's important to have a strong reasonable suspicion policy. And so these are just sort of the options that some companies are taking with respect to the issue. Again, there's no right or wrong. There's no bright line unless you're regulated and you're forced to by the government or some sort of government contract. It's really going to be up to you and what your stakeholders have decided is most important. So a couple of other things. I talked earlier about CBD oil. This is definitely a product in need of an oversight. I wrote a very interesting blog a couple years ago because I got really interested in this issue about how it was impacting workers and companies. The problem is, as I mentioned, is the FDA does not regulate CBD right now. So CBD companies, no dig on them, are putting out products that say THC free or pure CBD when studies have shown that's not true. I think in my blog, I cited to a study that scientists did of one particular company that had 11 or so different products. And most of the products that were tested actually had sufficient THC in them for somebody to test positive. I think one or two of the products had spice, which is some street drug, in them. And a lot of them didn't have enough CBD in there to actually have any sort of medicinal value for the person taking it. And so what we're seeing is that, and this happens all the time, a company will call me and say, so-and-so tested positive, and they're saying it was the CBD oil, the cream that they put on their shoulder. That might be true, although with whether you're rubbing it in and then you're able to fail a drug test, I don't know that scientifically. What I do know is that some CBD products have enough THC in them that, depending on how much the person is using, they will test positive for drugs. And so this puts the company in kind of a conundrum where they have to ask themselves, okay, what do we do here? Do we believe them? Maybe they really are smoking it or ingesting it on the side and they're just blaming it on the CBD product, right? What do we do? And so for the sake of consistency, a lot of companies will just treat it the same as any other THC product or THC test. What's happening, though, is that now workers are getting upset because they're losing jobs. And so we actually know of one case, I don't even know if it's still pending, but I saw it filed maybe a year or so ago, where a trucker sued a CBD manufacturer because he made this claim, which was that I've been using CBD oil that touts itself as THC free or pure CBD, and I tested positive for THC. And we're going to start, I think, seeing more litigation like that. So hopefully the FDA will figure out what it wants to do. Virginia, again, as I mentioned earlier, did recently pass last year the first law in the nation that provides protections to those who do use CBD oil. So that's something to think about. I'm guessing we're going to start seeing more of those laws passed across the country. I mentioned earlier drug and alcohol testing policies. I do know some companies, marketplace companies, that have drug and alcohol testing policies, and they do go ahead and follow the requirements in some of the regulated states, just because there's really no harm in having a policy. I'm a big fan of a drug and alcohol testing policy for any company because it highlights for the person what you're expecting, what your rules are, so that there's just no surprises, right? And so it's important to consider too, though, if you are going to follow the drug testing requirements in some of these jurisdictions, to keep in mind that they're pretty regulated in Boulder, San Francisco, Iowa, and Minnesota. Like, for example, in San Francisco, random drug testing is not allowed at all, period, end of discussion. And then Iowa and Minnesota have very, very detailed policy requirements. The state of Maine requires that the policy be approved by the state, so that can be kind of a pain. Some of our policy requirements we just know based on case law. So California, surprisingly, just it shocks people all the time when they call and ask me about California. I always say, well, there's no drug testing statute, so we just got to go off case law. If you do have a drug testing policy, I suggest that you have a very clear definition of illegal drugs and you refer throughout to that. So this policy prohibits, it's a policy violation to use, possess, consume, distribute, sell, whatever, illegal drugs at the work. And the reason is that if you're not clear about what illegal drugs means, then there's somewhat of a loophole in your policy, because somebody might test positive for marijuana and then they'll say, well, it's not a violation of this policy because it's not illegal. So my policies always have a very clear definition of illegal drugs, which includes cannabis, the cannabinoids, CBD, THC, things like that. It also folds within it the definition of Schedule 1 from Controlled Substances Act. And then it also, if you want to go this far, it has language stating that while marijuana is still, that marijuana is still illegal under federal policy, and even though it might be illegal at the state level, it's still a violation of our policy. That way people can't try to wiggle out of it and say, well, it's not illegal, and therefore it's not a violation of the policy. So just something to be careful there. California is the only state in the jurisdiction, shocker, that treats drug test results as medical information under state law. And so that means that there's a separate consent form that anybody who's submitting to a drug test needs to sign in order for the lab to share those results. And so if you are drug testing in California, and I'm pretty sure this doesn't just apply to employers, if you're drug testing in California, make sure that you're using this authorization for release of medical info. It has to be in font 14. It's my favorite part of the statute, so I don't understand the point, but whatever. Okay, so just some closing thoughts before we go to some questions. So if you are drug testing, I know a lot of this might not apply to you, or you're not necessarily, since there's some ambiguity or uncertainty right now as to how these laws are going to apply to contracted work and independent contractors. If this is something, though, that you are starting to discuss internally, you want to be ahead of it in the event there are some rulings or holdings out there that these laws do apply, I think it's just a good idea to get together your relevant stakeholders to talk about the issues and what you want to do about it. This could be safety, might be operations, legal. Those people can kind of all come together and find out, what is it we're doing now? What do we want to accomplish? What are our goals? Always understand, as part of this discussion, what rules apply and what don't. Can you even test depending on where you are? And then if you're following any of the drug testing statutes, or you just want to have a good drug testing policy, just make sure you review that, make sure it's clear so that people understand what's expected, what are the consequences. It's important for them to also know what your views are about the issue. And I didn't mention that is one other consideration, right, is that companies might not want to have the reputation of being anti-pot. I'm not necessarily sure I've ever heard of anybody getting that reputation, but again, it kind of goes back to the culture and then the need to make sure that you're attracting good talent, right? What sort of a message and, feeling do you want to put out to those out there with respect to this topic? And I have no opinion one way or the other. I just throw that out there as something to consider. So that's all I have. We do have a couple minutes for questions if anybody has a question. If there are no questions, please do reach out to me. If you need anything, you want to noodle any issues, I'm always happy to help. I'm really glad you were all here. I hope you got something out of this today.
Awesome. Thanks, Jennifer. So we did have one question come in. And again, if anyone else has any, please submit them on the panel. Our question is, with different laws around the world regarding marijuana, what is recommended for platforms that serve global audiences as far as what is allowed on platforms? And then they noted, with some states legalize marijuana on a federal level, is it still considered illegal? And should platforms follow the state or federal law as far as profiles for cannabis-related content?
I'm not sure what I mean by cannabis-related content, and I don't have any expertise in any of the global laws. I will say that it's still illegal at the federal level. It is in the U.S. Code under the Controlled Substances Act, and it's a Schedule 1 drug, which means it's illegal. And so that's been creating some, again, conflict because companies feel like if they follow the state law, so if they follow California, which has recreational and medical marijuana laws, does that mean they're somehow also violating the federal law, right? And there were some cases early on where workers would sue the company, and the company's defense would be, I can't allow this person to work for me because company will be in violation a federal law. And the courts would say, well, no, that's not true because the federal law doesn't say anything about employing people. It just says that it can't be sold or distributed or things like that. And obviously an employer or company isn't doing that by engaging somebody. In terms of, but I'm not really sure I'm understanding the cannabis related content. I think that would be something that, I mean, there are a lot of attorneys out there that focus on marketing and advertising or things that regarding cannabis that can actually be posted out in the public domain, and that would not be me. It sounds like an interesting issue. I wish I could answer the question, but I cannot.
Yeah, thank you. And the same person said they're thinking Twitter accounts as far as content and public profiles displaying other content about cannabis.
Yeah, I don't know. I understand the question. I just don't know. I don't know the answer to that because I don't think any of these laws these laws and issues that I've been talking about today would regulate that. I think that might be more of I don't even think it's an FDA issue. Yeah, I don't think anything that I've talked about today is going to impact that separate issue.
Okay, thank you. And do you have any closing remarks before I take it from here?
No, I think like I said, thank you everybody for attending. And again, reach out if you have any questions or you need anything. I'd be happy to help.
Awesome. And again, Jennifer, thank you so much. It was really interesting. Thank you everyone for joining us today. As a quick reminder, check out marketplacerisk.com to access this recording along with hundreds of hours of content and to subscribe to our email newsletter to stay up to date on all events. I hope everyone has a great day and thank you for joining us.
Thank you.